Oh, hang on. Let me get properly in here. Uh, let me get. There you go. That's the button. Um, oh, sugar and spice, all things nice. Hang on. Right. Oh, sugar and spice, all things nice. What did I do? Oh, and again. Right. Lee Dye's here. Josie's here. Erin Hack's here. Um, and Dylan's just tolerable. Thank you, my darling. As long as Dana didn't get redirected, it's fine. I just want Tracy to be here. And then, hey, Katie. Hey, Lady Di. Here she is. Hello. How are we doing, Tracy? Nice to see you, my darling. I'm missing you. Hope you're doing well. I'm joking. I miss Dana as well, but miss you more, Tracy. Hope you're well. He's all right. Not guilty. Yeah, force of habit. I know. Hello, Lady Di. Hello, Keith. Lady Di must have transferred to a new school. She thought she had a day off. She's going to get some black marks come Monday. She thought she had the day off. Lazy. She's in bed. She must actually be working. Yeah, probably. To be fair, I did tell her we weren't streaming. She could be pissed at me as well. There you go. Nice to see you, Tracy. Yes, as always. Right. Dennis, I got some second energy. I spoke to Dennis Sweeney this morning. They had the Canton standout 12 till 2 today. Got to speak to wonderful Brenda Sweeney as well. I got to chat with Timmer this morning as well, and to Dennis. So shout out to you. I hope you all went well today for you, Dennis. So here you go, Sally. How are you, my darling? Nice to see you. About sitting shotgun on your bus. Sarah P. So those that don't know what Erin Hack's bus is, if you feel you're a bit lost, Erin Hack's got you. Here she is.
Erin Hack, she drives a bus, yellow bus, yellow bus. Erin Hack, she drives a bus all day long.
Right. We have got a pre-trial hearing. It's only like 18 minutes, but we'll watch it and we might do some other stuff about Brian Walsh. Wicked! Here she is. You didn't get redirected. No. That sucks. There you go, Hackster. You know you love it. Hack has got 2 songs. There's not many people who got 2 songs on my channel. Hack is one of them. Here she is.
Leo, 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 Erin Hack, 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 ole! Erin Hack, 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 ole! Let's go, Erin Hack, 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 ole! Erin Hack, 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 ole!
Right. Shall go into it. Where is it gone there? Right. Before I go into it, please we've got 27 people here, only 8 likes. Please, can you like the stream? Because if you like it, we might get some old people like Heather Taylor back in the stream. So if you like it, we might get an appearance from Heather Taylor. So please, please, please like it because we would love to get an appearance from Heather Taylor. I've been here forever, so you have 25 months. Exactly. Hey, Josie. Oh, here she is. Here she is, everyone. Heather Taylor. We've missed you, Heather Taylor. Yeah, 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 Heather Taylor. I missed you, Heather. I hope you're well, my darling. Nice to see you. That means Potty Mouth is going to be in the chat now. Hello, lovely. How are you, my darling? Nice to see you. You summoned Heather. Yeah, thank you for summoning her. It's nice to see you. It was commenting back to Lady Di when it ended. Oh, okay. That's fine. That's fine. There you go. Hey, Stephanie. How are you? Nice to see you. Hope you're doing well as well. Yeah, hope everything's well with you. Lady Di with crop. Sorry, wicked. Seth says, what up, bitches? What up, bitches? How are you? Oh, of course he's joking. Of course he's joking. How you doing, Seth? Hope you're well, brother. I'm glad that you let Heather back in our chat because we've missed her. I've missed you like crazy, Heather. It's nice to see you back because the chat is never the same without you, Heather. So lovely to see you, my darling. I hope you come back more often. Right. We need the cool regulars back in the chat. There you go. And Heather is cool. It wasn't your fault. It was my typing. Hey, Sally, I'm mine as well. Joe, what the bitches part at least. XO, there you go, my darling. Nice to see you, Heather. Right, we'll put this in. That's what she said. And then we'll watch the Brian Walsh. It's only, I'll say, 18 minutes, but I did spot it, so we need to put it in. We need potty mouth. Yes, there's enough potty mouths here, but stand out with Timmer. Argument with Chris Albert Jr. Colin yelled at Timmer. Colin yelled at Duckman. Oh, Richie Schiffer gave us finger. Chrissy called cops. Great day. Typical day in Canton. Typical day in Canton with the Alberts. Bunch of pussies. There you go. There you go, Heather. There you go. It's always an interesting day in Canton. If you're ever in Canton in Boston, go to the Standhouse every Friday and Sunday. Thank you to Dennis and Brenda for keeping them going and for arranging them. Canton losers, yes. By that we mean the Alberts, not the Sweeneys. Sweeneys are winners. Right, here we go, everyone. And I'm actually going to be in Boston when this trial is on. So, Dennis, I was talking to Dennis, we might actually try and go in for one day or even a couple of hours if we can to court. So we'll see how they die. There you go. A little bit confused. Thought it was a day off today. Yes. Well, I've just come off a 2-hour stream. So we've just done a 2-hour stream, and now we've got this one lovely. So you might not have the notification for the first one, but this is my second stream for the day. So and I'm enjoying it. So it's good. Hippie Chick with an appearance as well. Hello, my darling. Nice to see you. Yeah, I did miss you. I did miss you. Hip 5. Right, here we go. Right, have we got many more likes now? Right, we got 17 likes. Okay, still 50% of you haven't hit the like button, but we'll progress with that. When you get a chance, please hit the like button. Right, here we go, everyone. Let's press this then, because just in case we get lost with Dennis here, because when I'm wherever with Dennis, we always get lost. Unless Brenda's with us, then we don't. Right, hang on. I'm going to try and find another stream. I don't like this because he's covering his face. Hang on. Let's have a look to see. Bear with me for a second. See if I can get another one with a better angle. We want to see the mofo's face, don't we? Baby, baby, we got Heather, baby. Yeah, yeah, yeah. Baby, baby, Heather's back. Yeah, baby. Right, I don't think there is another one. Brian Walsh. No, that one. 7 days ago. No. I think that's the only one we got. So we'll deal with it. This is today, Lady Di. Yes, this was today. Literally just happened. It just finished now. So this is fresh today, people. This is from today. When I can find it again. There we go. I got it. This is today. So bear with us. Here you go.
It should be a Yes.
Court's now in session, you be seated.
I may proceed, Your Honor.
Yes.
Thank you. The matter before the court is Commonwealth versus Brian Walsh on docket 2382CR0091. This is a Norfolk County Superior Court case. This is being recorded in Plymouth County Superior Court Room A. Mr. Walsh is present via Zoom, beginning with the Commonwealth. If you please state your names for the record.
I'm Franklin. From Thursday. From Franklin. I don't know, something in that. Franklin.com, you go first, you man.
Hold on. All folks on Zoom, I need you to mute yourselves. All right, go
I
ahead.
got one from Prelude.
Some people,
Anyone on Zoom, if you're not a party, you need to mute yourselves.
some people are stupid on Zoom. So
All
stupid.
right?
What's that for you?
Madam Clerk, mute everybody.
I'm trying, then we won't really have.
I understand that. So if you mute everybody and then unmute Mr. Tipton, Ms. Yaz.
It won't allow me to. Can you see if Sarah is available? I need an expert. I can ask counsel to unmute, but.
Well, what a fucking shit show.
I don't know that they have the power to do that without you,
Yeah, I don't know.
if you mute everybody. But I know there is a way around it because
Well, I'm unmuted, Judge.
I've had this problem before.
There is a way around it, but I just don't know how.
It appears that everyone is now muted.
Well, importantly, Attorney Tipton is now muted. Greetings.
I'm trying to mute everyone except the parties. Hold on. So I did mute everyone. Muted everyone.
Right, people, let's just remember, right? Let's not blame these people. You know, we all know whose fault it is. He's got one job to do, and he fucks it. He's not in chat today. He's there in Plymouth, and he literally only has to unmute everyone, and he's failed us. Dana, what are you doing?
That mutes it through the system. No one will hear you.
Okay.
Hello, Kim.
You're still calling.
Goddamn Dana. How do you deal with him, Tracy? How do you deal with him? I love Dana. I love Dana.
You are muted. You are unmuted.
Yeah,
How are we doing, Kim?
NDA.
They have to unmute on her side. It's not
Okay.
us. So I just asked them, see if they both unmute.
There's 7 minutes left of this.
This?
That will be muted because it goes through that.
Yes, free Aaron Spencer, free Zachary Anderson.
All right, again, for the record, Your Honor, Commonwealth versus Brian Walsh on 2382CR0091. Mr. Walsh is present. It appears everyone has now been muted except the parties, beginning with the Commonwealth. If you would please state your names for the record.
Good afternoon, Your Honor. Greg Connor for the Commonwealth. With me today is Tracy Cusick from my office, Gordon Watson from my office, and Ann Yaz from my office.
Good afternoon, Your Honor. Lisa Beatty from the Commonwealth.
Good afternoon, Your Honor. Larry Tipton for Mr. Walsh, who's also on Zoom. Attorney Porteous will not be here today.
All right, welcome to all the lawyers, and good afternoon, Mr. Walsh. So we were scheduled this afternoon to sort of hear an update on this issue. I want to alert sort of the defense to something, both parties to something. It could go either way, and see if people have any objection after consultation with your respective clients. It appears to me that there certainly could be an appearance of a conflict that I have vis-a-vis the Commonwealth's choice of attorney. That is, the Commonwealth has chosen attorney Michael Sullivan to represent them in connection with their dealings with the United States Attorney's Office. And that choice of an attorney is a mentor of mine and a friend of mine. And so it seems to me that although I have, as they say, searched my conscience to see whether I could make an objective decision, recognizing the nature of this decision in particular, and I'm confident that I could be.
I stop it there because where was Auntie Bev's fucking conscience with a conflict of interest? Now this, oh shit, I just knocked everything off. At least I think she should recuse herself personally, but at least she brought it to the attention of the court. Where was Bev? When she knew the party, it was like, oh, no conflict. Just dismissed it. She didn't even admit to any conflict. Wow. Good to see you, Cully, my darling. Lovely to see you, my darling. So this is what you're supposed to do. It should have been the defense bringing up the conflict. It should have been her bringing up potential conflict. She never did. This judge, at least she's bringing it forward, giving both sides the opportunity. You know, the Commonwealth put a attorney in place that used to be her mentor. She says that she thinks she can still do the job. However, she wants to give the opportunity to both sides. Fantastic. Let's listen to what happens.
Fair in any decision making. I also feel that it's appropriate to let the parties know that and for you to consult with your client. If in fact you prefer I not to resolve this issue relating to, we'll call it the federal materials, as a result of the fact that the Commonwealth has chosen an attorney who I formerly worked closely with, then seems to me that it might be best and most efficient for you to resolve this with Judge Krupp and with the other cases. So first, to the defense, do you wish to consult with your client about that, Attorney Tipton? In fact, I think you need to consult with your client about that. And or do you have any additional questions for me?
I don't have any additional questions right now, Judge. Yes, I would need to consult with Mr. Walsh.
All right. And based on the Commonwealth has a perfect obligation to, right to say we don't like it either. But you can think about that. It seems like based on the minimal information that I got, I was expecting that the parties were going to say we need more time anyway. And so Judge Krupp has a hearing scheduled for the 5th. So if it turns out that either the parties aren't comfortable with me going forward, given what I've disclosed on this particular issue, and I don't think that it relates to any other issue in the case, then I'll send you off to Judge Krupp probably. Although there's another judge here that could hear you in Plymouth County, but since Judge Krupp already has the issue before him in a series of other cases, that would seem to be the most efficient. Anybody else have any other ideas of where you go? I hear none. So why don't we do this? Attorney Tipton, I think that Madam Clerk can get everybody else off and allow you, if you wish, today to consult with your client on Zoom. I think we should just put this hearing off on this particular issue until next week. Until you've had a time to adequately consider the issue.
Bye, right? Heather. Good luck, Heather.
Now, separate and apart from that, I realize that we don't, what, if any, other dates do we have leading up to October 20th other than the final trial comments?
We have our filing deadlines for motions in limine, Your Honor, and we have our final pretrial hearing, I believe, off the top of my head, I think it's October 9th to October 7th. Everyone in the room just corrected me. And so those are the next dates I think we appear in court is October 7th.
All right. Anybody see the need for any other interim date?
Judge, I think that we would be filing a motion for change of venue, but I think it can be handled in the normal course in the
motion to eliminate. Okay. All right. I'll look for that along with obviously any other important, or they're all important, motions to eliminate. So, but if something comes up and you need to see the court, you know where to find me. Otherwise, I'll plan to see you in October. And that's presuming, we're just putting a pause on this issue that we're flagging right now until you've had a chance to decide how you want to handle that, all right?
Yes, sure. Yes, Your Honor.
All right. Thank you very much.
Thank you. Thank you.
Oh, jeepers. Change a judge and change your venue, possibly. Where would they go then? Because they're in Plymouth now. Where would they go to Plymouth Court? Oh, yeah. How are you finding yesterday's stream now? Yeah, is it all right? Good luck to you, Heather, your job interviews. Where would you go from Norfolk County? Dennis, we're not going to this trial if it's in Plymouth. Very interesting. So change of venue possibly and a new judge. I will say though, that is how you're supposed to deal with it. In some ways, I wish you'd have just recused yourself, not to put them in that position, because basically, if they have to get a new judge, then that stalls everything. I don't know about that, if I'm being honest. It is interesting. But I'll give a credit. But also, what mofos, the prosecution, why are they introducing, because that attorney they just introduced knows there's a conflict with the judge. Why would he not say something to the prosecution unless the prosecution are trying to push the judge out or something? Do you think that? Do you think the prosecution don't like this judge and are like, well, we'll get someone in that she'll have to recuse herself potentially? Because why would he do that? I don't get that. Can you imagine Wicked? Can you imagine Wicked if he got this case? Woo! But that is very, because everyone knows everyone's backgrounds. So that attorney they've just appointed would have been like, hey, just so you know, this judge did mentor me. So I don't think I can take this role on. Or they went, oh, no, we want you on here because we don't want this judge. I was cheating, and Melanie said it's only for this issue, not the whole case. Repeat, hippie chick. What? Oh, change of venue. Do you mean the change of venue bit? Or do you mean something else? Hippie chick. Because I can. So, do you mean the trial though? It's only. I'm just a little bit confused. Sorry, hippie chick. I'm confusing it. So, when I say it's only for the issue, not the whole case. So, you think the trial will stay in Norfolk County, but the hearing will be somewhere else? You would be okay on this one. Your son will be fine. Okay, your son will be fine. Let's listen again. I'll listen to it again. Because the reason I say that is because they're gonna discuss it. Let me play that again then, see what he says. Because I didn't catch that. Because they said they'll sort it during the next hearing, which would probably be the hearing they discuss it in. So
Judge Krupp has a hearing scheduled for the 5th. So if it turns out that either the parties aren't comfortable with me going forward, given what I've disclosed on this particular issue, and I don't think that it relates to any other issue in the case, then I'll send you off to Judge Krupp probably. Although there's another judge here that could hear you in Plymouth County, but since Judge Krupp already has the issue before him in a series of other cases, that would seem to be the most efficient. Anybody else have any other ideas of where you go? I hear none. So why don't we do this? Attorney Tipton, I think that Madam Clerk can get everybody else off and allow you, if you wish, today to consult with your client on Zoom. I think we should just put this hearing off on this particular issue until next week. Until you've had a time to adequately consider the issue. All right?
Yes, Judge. Yes, Your Honor.
Now, separate and apart from that, I realize that we don't, what, if any, other dates do we have leading up to October 20th other than the final trial conference?
We have our filing deadlines for motions in limine, Your Honor, and we have our final pretrial hearing, I believe, off the top of my head, I think it's October 9th to October 7th. Everyone in the room just corrected me. And so those are the next dates I think we appear in court is October 7th.
All right. Anybody see the need for any other interim date?
Judge, I think that we would be filing a motion for change of venue, but I think it can be handled in the normal course in the
Motion
final
eliminated.
control.
Okay. All right. I'll look for that along with obviously any other important.
the issue I have that because he says that they are filing for a change of venue, but we can sort that in the motions for limine hearing. I don't. Maybe I'm misunderstanding it, but I understand that as in not the next hearing because they're going to discuss it in the next hearing. I'll be honest with you. I am a little bit behind on this case, so I'm not fully. To be fair, I'm not fully up to date on this. So I'll go back a little bit more so we can hear it again. Listen out to this yourselves.
Pretrial hearing, I believe, off the top of my head, I think it's October 9th to October 7th. Everyone in the room just corrected me. And so those are the next dates I think that we appear in court is October 7th.
All right. Anybody see the need for any other interim date?
Judge, I think that we would be filing a motion for change of venue, but I think it can be handled in the normal course in the
Motion to
final
eliminate.
control.
Okay.
You see, so they can file for a change of venue, but it can be handled in a normal course of the hearing for motions in limine. So if they're going to handle it there, then surely, again, look, yeah, maybe I've misunderstood that. It just, I don't know. But anyway, it doesn't matter. But yeah, I'm sure that others know better than me on it. It's just, but to me, that just sounded like the next hearing they're going to have, and they're going to discuss the motion to change a venue, which would then be the trial. Unless there's something in between that I don't know about. Maybe there is, but that's not how I interpret that. But I'm not going to go against what anyone else says. So, right, I don't know what issues what they do. I don't know. Right, I am going to. I am behind this. So maybe this is why I interpret things differently. I am going to play this because I have not listened to it yet. And this is, and I know everyone else has. So this is the last week, the hearing they had last week. So I'm going to play this because I've not heard this. So maybe that then will make more sense in what has just gone on there. Because I am very much behind on this case. So I might as well play this now because I was going to do it in my own time anyway. So those that want to watch it, they can. If not, no issues. So Brian Walsh returns to court. This was 8 days ago. Here we go. They also say he's a tall mother, mofo. Corey Richards' case, yes. Adelson, I have not followed it, but I probably will follow it. Right. The judge is coming in here, so. Hey, Heather, how are you? Heather is from Roll Tide, Alabama. So if you don't already, please go and follow Heather at Facts, Opinions, and Real Talk. Heather was in Boston the same time as I was. Nice to see you, my darling.
Proceed, Your Honor.
Yes, please.
Thank you. The matter before the
Hi, Patty.
Commonwealth versus Brian Walsh on the Norfolk County docket 2382 CR 0091. Mr. Walsh is present, represented by Kelly Forges and Larry Tipton. Commonwealth is represented by Assistant District Attorneys Ian Yaz, Gregory Connor, Lauren McLaughlin, and Tracy Cusack. This is on for a hearing on a motion to dismiss.
Good morning, counsel. Please introduce yourself.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, Mayor Laura Loughlin. Good morning, Your Honor. Tracy Cusack for the Commonwealth.
And Ms. Yaz is sitting behind us.
Not enough space for her?
Hopefully you'll let hear from the three of us today, Your Honor.
All right. I appreciate everyone being here, and I see that you have a new.
Yes, I'm working
Heard
on
about that the last time we were together, so I'm glad to see you.
Thank you, Your Honor.
Welcome to the family.
Good morning, Your Honor. Good morning, everyone. Kevin Porter on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh, and I would just ask, once again, in my request to have his handcuffs removed so he can use the pen and listen to the court.
And I spoke with the court officer this morning, and as I said to you, last places we've been, I follow the rules as they direct me. And in this instance, I understand that the court officer is comfortable with that, so his cuffs will be removed. else that you want to bring to my attention. Of principal concern to me today is the defendant's motion to dismiss, and also motion with regard to the, I'll call it the federal protective order. And I just want to address that specific to this case. I think that we were all on a call, we're all listening to the same hearing before Judge Rupp. I didn't feel the need to necessarily engage myself in those hearings and let it play out. As you know, I sort of put a temporary hold for a hearing last Friday, which I ultimately decided we didn't need to do because of the events as they progress. We can talk about that as well today, and how that particular issue impacts this case, which may be very different than some of the other cases that were involved in this prior year. But I'll hear on those two motions, and then again, anything else that you wish. So let me just tell you where I am with regard to my level of preparation so that you can respond accordingly. I have read all the days of the grand jury transcript. I have read, I'd probably say 75% of all the documents that were presented to the grand jury. And that 75% is directed towards the issues that I thought were important today. So for instance, I didn't spend any time looking at records that related to airline. I didn't spend any time looking at grand jury records that related to finance. Maybe the argument isn't made with regard to what's contained in the record. So I read all relevant, what I thought relevant grand jury exhibits. I've obviously read your motions, and so as a preliminary matter, that's where I start. Defense's motion. I'll hear from the defense first.
Thank you, Judge. First thing I want to address is this, the interpretation of driver. We cite
Like I can hear it, but I can barely hear it. Right, is there something else then? Let me just check because that is awful. Let's have another look to see if there's anything else. Let's have a look. Let's have a look. Brian Walsh. Because that was absolutely diabolical. Sorry, Tuddy Pip. It was just so low. Right, I found another one. Oh, sorry. Sorry, Wicked. Yeah, I do apologize, everybody. I found another one that might be a little bit better, but it starts off really low, but I think it gets better. So let's watch this one. It's a little bit low.
indicate that he's planning,
Here we go.
Why isn't that was having an affair probably as early as December 25th, 2023, 2022. And there was his motive evidence with regard to the
conundrum of the federal prosecution and its pending sentence. That's all before the jury. As I understand their argument, it is that those searches that are done, and there's 8 of them done before 6:35 in the morning, are prior to. And even though it's reasonable to say that those searches relate to what you do once you have a dead body, that it's not inconsistent with the fact that he may not have yet killed her at the time that he did those searches. Those are the reasonable inferences they're saying that a grand jury could have found. Why isn't that within the bounds given the evidence that was before the grand jury?
First, the Commonwealth says, on the one hand, based on the statement of the defendant that and of the young child, that he saw his mother. And then they go on to say, but the defendant was coaching him. And then at the grand jury, they go through an enormous amount of effort to dispute whether the child actually saw her. They put on witnesses talking about everything from how well he understands English, the young child, what he does, what he doesn't understand, that he couldn't have created the searches. But they go on to try to dispute that what the child said is not accurate, and it's the result of coaching by the defendant. That's what the Commonwealth presented. We weren't there, but that's what they presented. Let me talk about the insurance. The court used the word motive. It's possible motive evidence, but motive evidence is not premeditation, and motive evidence is not malice. And there is nothing untoward about life insurance policies named in anybody's name. And there were still life insurance policies presented to the grand jury that still had Miss Walsh as the beneficiary. So now we look at that quality of evidence. It may be some evidence of motive, but it is not evidence of premeditation. It is not evidence of malice, according to the case law. And there's nothing in these.
Well, but the evidence of malice that they're going to rely on that was before the grand jury is certainly contained in those searches.
If the searches happened before.
That's their theory.
That is their theory, but
one of their theories anyway.
But their evidence presented to the grand jury doesn't establish that, and it requires the grand jury to speculate and pile inference on inference and say, well, maybe it could have, maybe it, I don't know what the grand jury was thinking.
All they have to believe is Mr. Walsh's own statement that she left at 6:30, right? And those searches.
But I think what the court is saying is the grand jury heard sufficient evidence to establish that somehow, that contrary to what the Commonwealth presented to the evidence, the grand jury can still ignore what the Commonwealth presented, and that is they disputed that the child saw his mother at 6:30 in the morning. So you can't just throw, forgive me, but you can't just throw things against the wall and see what sticks, and then walk away and say the grand jury heard sufficient evidence. And because that is the probable cause to arresting.
They don't need Thomas Walsh, excuse me. They don't need the minor's statement to establish probable cause. They can go at it alone with Mr. Walsh's statement, she left at 6:30, and the fact that those 6 searches are done before then. Isn't that sufficient? Counsel, we're talking about probable cause.
Judge, but what?
I'm not talking about proof beyond a reasonable doubt.
No, I understand that. I'm talking about probable cause to arrest and reasonable inferences on trustworthy evidence. What did the Commonwealth do in front of the grand jury? They tried to demonstrate that Mr. Walsh lied about Anna Walsh leaving at 6:30. The Commonwealth spent more than a day putting on evidence that she didn't leave at 6:30. She never left. So what he said was a lie. And that's the quality of the evidence that was presented to the grand jury. So if now the government wants to stand up and say, well, we want to have it both ways. We called him a liar in front of the grand jury. And we don't want the grand jury to believe that she left at 6:30, but we're going to rely on that very same evidence to construct this argument that, oh, as they say on, I forget what page it is, I have it, but they say that in a cryptic one sentence, maybe those searches happened before. And that's all they do.
All right, what's the argument? Let's change the playing field and say the argument is that, because they could pursue alternate theories, that she was murdered prior to the searches. So your argument with regard to lack of any probable cause before the jury is stronger, right?
I think so, yes.
All right. Anything else you want to ask me that you want to tell me?
About premeditation?
Yes.
We shouldn't discard the fact that premeditation requires, I understand there's a lot to do about the time element, and I'm not even going to recite all that case law, but it does, the case law also makes clear, and I cited to the model instructions for homicide on premeditation, that it's not just that someone says, okay, I'm going to kill somebody. There has to be cool reflection, there has to be a thought, and then it has to be followed by action. They have no evidence of that. If the evidence is that now they want to construct an alternative argument that, okay, even though we wanted to convince the jury that Mr. Walsh was lying about 6:30, Anna Walsh leaving at 6:30, and even though we want to try to convince the grand jury that he coached his son and his son never saw Anna Walsh, we will nonetheless use that as sufficient evidence to get the indictment based on premeditation. That is not due process. And that's exactly what they did at the grand jury. They disputed the evidence. They did not endorse it when it came to what time she left and if the son ever in fact saw her. And now they want to use it. If they try to use it, they want to use it to say, therefore, the searches happened before the death. And the grand jury is entitled to do that. When in fact, the only evidence they presented to the grand jury was, you can't believe she left at 6:30, and you can't believe that the son saw her.
So the two of you are going in different directions on the significance of the destruction of evidence. That is, the Commonwealth cites to, and I will candidly acknowledge I haven't looked at the different cases that you cited. I certainly will before I make any decision on this case. But the Commonwealth cites to the defense's argument that is sort of that destruction of, under the law, the destruction of evidence is not relevant to the issue of premeditation. And the Commonwealth cites me to, I'm going to butcher the last of this, I'll spell it so I don't butcher it, Dageneais, Dene, a 2002 case for the proposition that evidence of destruction of evidence is highly probative on the issue of premeditation.
Well, I think what that, I'm sorry, I don't want to interrupt.
Go ahead. That was the end of it.
Okay. And I too don't want to butcher the case name.
You can call it just D.
We'll call it D. Look, all that case said was, and the Commonwealth uses it in their memo, all it says is there's no blanket rule.
Prohibition against it.
That's right. But then you have to look at all the other cases that talk about that, and all the other cases, Blakey and all the other cases that we saw, say, well, it doesn't have any bearing, destruction of evidence doesn't have any bearing on premeditation if it happened before the blow. That's the phrase used in Blakey, before the blow was struck. That is bedrock case law. That's what they're talking about. So now, getting to your point, Judge, what is the case that they cite and is Nadworny? And I think that Nadworny talks about, consciousness of guilt evidence that may be used, may also be used to demonstrate, let's say, intent. And it goes hand in hand because there's a difference between the analysis of premeditation and intent. But what Nadworny case way back in the 70s says is that on those facts, you could consider the condition of the body found in the trunk of the defendant's car that had been in the trunk for 4 months and showed decomposition, showed that it was specifically wrapped up like a funeral director may do it because his father worked at a funeral director. And they go on to elicit all those facts of how that type of thinking can be impugned to that defendant. You don't have anything like that here in this case. And so the grand jury didn't hear anything of the sort like that. And Blakey says, as well as any number of cases, say that consciousness of guilt should not be used to try to prove malice or premeditation if you can't demonstrate that the so-called consciousness of guilt evidence, and I will say for purposes of this motion, it's probably likely that at trial, those searches would be considered consciousness of guilt if the Commonwealth can demonstrate sufficiently prior to introducing them that they were in fact created by Mr. Walsh and no other person, that they could be considered consciousness of guilt. But that's the limitation. And the case law that they cite and that we cite go on and talk about the errors that are asserted in appellate review where a defendant argues that you used consciousness of guilt to influence the jury on intent and premeditation. And what the analysis shows in many of those cases is, well, where the jury got a complete instruction on consciousness of guilt and premeditation and all the variations of malice, and many times these decisions are made by a substantial miscarriage of justice. But the point is, they're saying in those cases, we think the jury understood that you can't use that evidence other than consciousness of guilt. So in this case, you might have consciousness of guilt evidence, but that is not evidence of premeditation on these facts. You might have consciousness of guilt evidence, but it's not evidence of intent, and it's not evidence that establishes any of the 3 prongs of malice. And that's what we argue throughout our brief. I think I heard Your Honor refer to affair, the knowledge of the affair. Let me just talk about that for just a moment. And then I have to circle back and not repeat what I said, but I want to talk about inferences and how they apply to the arguments that the Commonwealth makes in their memorandum. First, I know the government wants, and they've said it to the public, but they're just wrong. Mr. Walsh did not know about an affair, period. What AK, and I'll just use the initials that I did in the memo, what AK told the grand jury was that Anna Walsh had talked about telling Mr. Walsh she had a crush on someone. There was no testimony by AK that Anna Walsh discussed with her that Mr. Walsh knew about the affair. It was ongoing.
I don't think that's correct, counsel.
Okay.
Let me tell you what I have in mind from reading. I just need to find the right piece of paper, but I will. AK testified that the defendant told Anna that his mother had told him that Anna was going to leave him for a guy in DC and take the kids, and that he believed that. That was her testimony.
I'm trying to think of that specific, I recall that specific testimony, but I don't think, I thought it said that Well,
59 to 60 of the transcript.
all right. Can you pull that up?
Your Honor, do you have a date from that grand jury?
March 8th, 2023.
Thank you.
The defendant told the police in his January 4th interview that he had access to Anna's iMessenger on his phone and some access to her Instagram. Those are the two ways that Anna communicated with WF for his testimony. Also before the grand jury was that he, the defendant, searched WF's name 6 times on December 25th, 2022. That there were 20-something, 21, 25 searches between the 26th and January 1st on his Instagram account. They don't know where they were too. Also before them were the messages between WF and Anna, which leave little doubt that there was an affair going on.
When the, if I may inquire,
So,
Judge.
I've got to assess the evidence that was before the grand jury in its entirety. And that was the entirety of the evidence that was before them with regard to whether there was an affair going on and whether he knew about it, right?
Well, that's not the entirety. I'm sorry, Judge. I don't.
Well, that's some of it.
That's some of it. It's not the entirety, though, because the entirety also includes the testimony of the other testimony of AK and the other testimony of WF. And that testimony from WF was specific that him and WF and Anna were talking about their affair and that she wanted to tell Mr. Walsh about it, that she would, quote, be devastated if he learned about it. And then there's this conversation about his mother hiring the psychic and that's where that came from. Hiring a psychic that told her, the mother, that Anna Walsh may leave the defendant for someone in DC. And then WF is asked specifically by the government, was there any conversation about Mr. Walsh knowing, I'm going to paraphrase, knowing about the affair? No. Was there any conversation about whether she had told him about the affair? She wanted to tell him about the affair at some point.
That evidence go to the issue of whether or not Anna knew that Brian knew about the affair, not whether Brian knew about the affair.
Well, when the court recites the fact that if we assume for purposes of this motion that Mr. Walsh is the one that reached out and tried to search for WF, how does that show? How does that demonstrate reasonable and trustworthy and reliable facts, articulable facts, that he knew about, quote, an affair, as opposed to the simple truth that was presented to the grand jury that she had a crush on?
Let's put aside the searches on the searches on the December 25th. Put aside the 21 other searches between those dates and just focus on his admission to the police on the 4th of his access to her Instagram and to her iMessenger and WF's exhibits of the messages between Anna and himself. As I said, there's little doubt based on what's in there. You know what's in there, that there was an affair going on, right?
And you're referencing the messaging between Anna and WF.
Correct, which the defendant told the police he had access to that during his interview.
He may have,
That was before the grand jury too.
he may have told, he in fact told the police that, yes, he had access to it. He never told the police that he read those text messages. He saw those text messages.
Isn't that a reasonable inference?
Why would it be? Why would it be a reasonable inference that jumps from the fact that someone may in fact be able to access messaging, but there is no, that he has access to it, but that in fact he did? Why is that?
I don't think that was his, I don't think that's his language on 1-4, but that he had access to it. I'll go back and listen to it again, but my memory of it was that they were coming up on his phone.
Okay.
But I'll go back and refresh that. But what did you want to, so this idea, this notion that that there's no evidence supporting the fact that he knew of the affair just doesn't seem to me to be a fair assessment of the evidence that was before the grand jury.
And what we're arguing, Judge, that it can only be a fair assessment based on reasonable and articulable facts of trustworthy information. There is no trustworthy information. There's no information at all that Mr. Walsh read Anna Walsh's messaging between herself and WF.
Does somebody have the January 4th interview, page 30, lines 8 to 22? I have it here. I just don't know exactly. Oh, maybe I do. Anyway, I'll go back and look at it. That's the area where, that is the location where he discusses in his interview on January 4th, his access. You may be right, it's access and not that he actually looked at it.
And I'll take a look and see if I'm wrong.
All right.
Could I just go back to pages 60 and 61 and that issue?
Great.
So I thought the court had recited in saying that there was testimony that Brian believed.
Anna believed, Brian believed. So I'm on 60, line 11. Diana was convinced that she went to a psychic, and that due to that, she was convinced that Anna was going to leave Brian for some guy in DC and take the kids, and that she believed Brian believed that.
Well, but that, maybe I misheard the court. I thought you said that there was direct testimony that Brian had represented that or there was a statement attributed to Brian Walsh.
No.
Okay.
He consistently, throughout his interviews, as I know them with the police, averred that he wasn't having an affair, and he didn't believe she was either.
Okay. So turning back to that now, Judge, line 11 at page 60. Anna can believe what she wants to believe. There is no factual basis presented to the grand jury that Brian Walsh did, in fact, believe that. In fact, the evidence presented that she was having an affair. In fact, there's testimony at the grand jury that this psychic investigation was revealed by Brian to Anna Walsh. So how is it then that when people are sharing information and nothing happens at that time, nothing untoward at all happens at that time, that the government can then move on and pile another inference on top of that inference and say, therefore, Brian Walsh believed there was an affair, and therefore Brian Walsh acted on that belief, and therefore there's evidence of premeditation as opposed to motive or whatever. But How can a grand jury be permitted to pile inference on inference when that's what the government is at, if in fact that's what the government intends? That's what occurred. There is no trustworthy, reliable information that Brian Walsh believed or knew about an affair. And when you consider the testimony of WF at the grand jury, and the testimony in conjunction with AK, did she ever say he was jealous?
Council, let's circle back to those December 25th, 2022, the 6 searches with regard to William Fasto on that day. So there are 6 searches that are done on a device that's attributed to Mr. Walsh for Mr. Fasto's name on December 25th.
Yes.
He was just randomly searching the guy's name on December 25th, the day that his wife is supposed to be coming home and missed her flight.
Well, he's trying to find out where she is because she's late, and she had to leave on the 25th, and she misses the flight, and she has to drive up.
And she thinks of William Fasto, or he thinks of William Fasto.
Well, he's also reaching out to others, I believe.
He didn't, as far as I know, the only information before the court from the materials that were in the grand jury is he searches William Fasto's name 6 times that day.
Okay, but William, she's already, if you believe what was presented to the grand jury, and that's the constraint we're under right now.
Sure.
She, according to AK, she told Mr. Walsh she had a crush on WF. So why wouldn't he? If your spouse says, I have a crush on this person, the other spouse is not allowed just to say, I want to learn about what that other person is.
When does, and this is up for grabs for either side, I have a question with regard to the evidence that was before the grand jury. Just gonna find that. So much paper.
You can't be an environmentalist, I'm afraid, and be a lawyer.
Not a lawyer that's this old anyway. One of the exhibits to Mr. Dozier's grand jury is a series of voicemails left by left by Diana. And I've listened to those files. My question for the more technically enabled people is, was it before the grand jury that file number 046, or any of the files that Mr. Dozier provided, time-stamped in any way? Does anyone know that from your review of the evidence?
Off the top of my head, standing here.
All right, so the Commonwealth, I know there's a lot of you over there, but if somebody can answer that question when you get up to argue, if you can, I'd appreciate an answer to that.
But talking about, and you're talking about the investigator.
Yes,
Okay.
and it was something you just said triggered that memory of sort of an open question in my mind, was whether or not the grand jurors had before them, other than by context of what's being said in those messages, the timestamp for the days those messages were left.
And we can get the answer to that question, but the testimony of Mr. Dozier under oath was that there was no testimony that he got in. That's the other interesting thing. He never got a name.
Well, he never gave the name. He had a name. They had a person of interest. It was WF. But he never provided that name to them. That was something that's how I recall his testimony.
And what I was about to say was, he never testified, and he was asked, or I guess asked in substance, no one like Brian Walsh gave him a name. And in fact, the government kept asking that witness, when did you ever talk to Brian Walsh? Yes, we did have some conversations. When did that occur? If my memory, I'm paraphrasing, if my memory serves me, it was sometime after January 1st. January 1st. So I think that's another piece of trustworthy and reliable information that someone could make an inference that at some point Mr. Walsh became aware of an investigation that his mother instigated, but there was no evidence that that investigation was informed by Mr. Walsh, and Mr. Walsh didn't have a reason to get on the phone and say, hey, apparently, to check out this WF guy. So that's why we say in our memo that when the government begins to spin out what it believes are reasonable inferences, they are not grounded in articulable and trustworthy and reliable facts. They are the ruminations of the Commonwealth trying to justify that what they presented to the grand jury is sufficient in making out the elements of the charge, even though, as I return briefly, they don't even attempt to make out the elements of extreme atrocity and cruelty when it comes to what was presented to the grand jury. Another final example of this, and I know the court didn't reference it a moment ago, but it's this articulated argument by the government that somehow, and they go on for almost a full page talking about the facade that Mr. Walsh created by making it look like to everybody that it was just a happy family, and that was his plan to present to GM this presentation that it was just a happy family. You know, Judge, what the grand jury, and that's the government's inference. Okay, what's the articulable and reasonable facts, trustworthy facts that establish that? Nothing at all. It's an inference that is created out of whole cloth, and it's used by the Commonwealth in their memo to suggest, see, that was his planning stage. That's what he was planning. Who invited GM?
On December 29th during the phone call.
And here's this long visit of hours where there's nothing but happiness and cooking and eating and a little bit of drinking champagne, and then at 1:30 he leaves. We recite all of that evidence because it is the trustworthy and reliable evidence that the grand jury heard and contradicts not the other evidence that they heard. It contradicts the inferences that the government is trying to make. Did it get across the finish line here on the grand jury presentment? And
well, I credit what you're saying, that this argument that he somehow in some planning phase called Mr. Lulu and invited him over for, I probably mispronounced that as well, but invited him over for dinner is contradicted by the evidence that Jim himself presented, and which he clearly said he was invited by Anna on the 29th. It's contradicted by the text messages between Anna and Mr. Fasto, in which she discusses inviting him over. So I credit that the evidence wasn't that that was a planning thing as far as the evidence that I can see before the grand jury. But also, it's clear that there was sufficient evidence before the grand jury that this marriage was in distress over the issues relating to his then pending federal sentence and the implications of that on their life and where the children lived. It was clear that AK was seeing something different than she had ever seen before in her friend, in her demeanor. She mentions that, in her, which a reasonable inference could be based on the context of that, which was she was talking about her marriage and the failings of her marriage, that their marriage was under stress. So while I credit you that this notion that he planned this by ordering or by inviting Jem over, there doesn't seem to be any evidence before the grand jury that I can see. They'll argue otherwise, perhaps.
And let me respond to some of that, though, Judge, some of the themes of what you just said. Once again, I'm going to very quickly refer to AK's testimony. Yes, friends with Anna Walsh, recited conversations with Anna Walsh, was asked specifically, did she ever talk about divorce? No. No. What did she talk about? She talked about the frustration of not having the 3 kids in DC and the time it was taking. And who was Anna Walsh angry with? She was upset with Brian, but she was angry at his lawyer because she thought the lawyer was the one setting up this idea that the kids had to, the 3 children had to stay in Cohasset. That wasn't Brian's doing. The government tries to argue that, but that's not what the grand jury heard. Also, AK testifies initially.
But what the grand jury heard is she was angry with him because she had learned that it was not the FBI, but rather Brian himself that was delaying his sentence. The sentence, delaying the trial or the resolution of that case.
And she goes on to, I understand, she goes on to testify that Anna Walsh then was talking about Mr. Walsh, Brian, had to take responsibility and that they needed to work through this.
Right.
And that's exactly what they were doing. To suggest that stressors, serious stressors that have been going on for some time, somehow transform into motive to kill, malice, or premeditation is once again an inference that is not supported. It is, somebody can dream up the inference like the government is doing here, but it doesn't rest on the facts, and it doesn't rest on the entirety of the testimony of of AK. The same thing with the WF testimony. You know, if what the grand jury heard was, yes, there was conversations, but there was never the only conversation that he recalled where divorce was mentioned was in terms of, quote, protecting assets. And I will just, that's it. That's all he recalled. And when the assets may have been the life insurance, it might have been the value of the condominium, 1.3 million. It might have been the other properties they owned. They were renting the Cohasset property, but maybe the other properties. But here is WF being asked a myriad of questions about, well, didn't she talk about this? Didn't she talk about that? No. She always, quote, I'm not quoting, paraphrasing. WF said that what Anna Walsh described Brian was basically this wonderful man. That doesn't sound like, and it can't be used to now construct some argument that whatever stressors were going on in the family then can be used to establish premeditation or malice in any of its forms. It is, as we say, it is piling inference on inference. And doing so is violation of due process in Article 12 because the grand jury wasn't presented that type of evidence. It is the inferences that are being constructed by the Commonwealth that aren't grounded in articulable facts, plain and simple. The other thing is about the money. They'd already started paying the money back. This idea constructed out of whole cloth that somehow one of his motives was to murder his wife so he gets access to monies so he can pay $450,000 that they'd already started paying for, and they had all these properties, just defies logic.
What was the evidence before the grand jury that they, since you mentioned it, that he had paid back? And
I think that, I know it's in the grand jury somewhere, Judge, because
Where?
I will find it. I'll give you a particular citation.
Anyone?
Where-
Mr. Walsh made statements one of the 4 days that he was interviewed by the police. He had explained, and I believe his attorney was present when they both represented that part of the money had already been
That's right.
paid back. And Tracy Minor indicated to the detective that they were trying to pay back as much money as possible prior to the sentencing.
Well, I knew that part. I
And they
appreciate
represented
that.
that money had been paid back, a number had never been given for the amount.
So it wasn't in the grand jury, it was in the exhibit.
And is there anything in the exhibits that were before well, that's in the grand jury. Exhibit.
I understand, but I was misleading when I said it was in the grand jury.
No, I think that's the proper statement. Before the grand jury was an exhibit. Was the federal docket that has been presented me, and I don't remember in connection with what at this point, because I have so many motions that I'm considering, but you know that somewhere in my travels, I've come across the federal docket to his federal case that was attached to something. Was that ever before the grand jury? I don't think so.
There was reference to the federal case.
Yes.
There's reference to the federal case. I was just wondering whether there's any evidence of payment in that docket. Because if there was evidence of payment in the docket, then it would be fair to say that they had evidence before them. Often, in my experience, when restitution is paid, it may not have happened here because the sentence doesn't happen until 2024. But that would have been certainly something that would have been noted. And they did get darn close, it looks like, from my recollection of my review of that docket to a sentence. But then I don't know what happened, but they retreated.
So if the grand jury
So they do have evidence in his statements that some restitution was
Yes.
paid.
and they did not hear any evidence that there was some conflict about, or some argument about the amount of money that had to be paid back. There's nothing like that presented to the grand jury. There were the stresses revolved around primarily the 3 children in the DC. And once again, AK testified about the plans that both Brian and Anna Walsh were trying to make to move the 3 kids up to DC. So what you have is testimony of stresses in a family grounded in what we'd all believe would be true. 3 young children living in one place, mother living in another, and they're trying to work this out, and it's taking longer than expected. How does that become a reasonable, articulable, and trustworthy fact to build a premise that stress led to premeditated murder or malice in any of its forms? It's pure conjecture, it's speculation, and it can't be the basis for this indictment. I don't want to keep going on here. I would like just to make clear something here before I sit down. And you can shut me down, Judge. I know you will if you want to, but it's this Riley thing. And let me just say briefly, I would be happy.
I won't shut you down because I'm not sure, I'm still not convinced that it's relevant to the decision I need to make on this motion. But
Okay.
it's certainly going to be relevant later, so that the earlier I get educated, the better.
So let me try to make, the argument that it is relevant.
Okay.
Because we do argue it. What we're saying basically is that the grand jury has to hear the elements of the offenses that are encapsulated in 265.1 statutory language. It's not, there's 2 separate bodies of law. 265.1, that covers all the theories, but that is a procedural issue. It's a little substantive, but it's procedural. Over here, we have all the case law, Moran, Walsh, and I believe, the way I interpret Riley, to say this: you have to present the elements. And for some reason, the way the justice wrote that opinion in Riley was, we want to clarify what we left open in DePace. He doesn't talk about Moran or anything. And what I think he's clarifying is, let's just be clear. In DePace, we talked about 265-1 because the challenge was on the face of the indictment. In Riley, we're talking about something else. We're talking about what the grand jury heard. And so under Moran, if the grand jury does not hear sufficient evidence of the elements of a particular theory of murder, then the indictment, as we're asking, that so much of the indictment that can be read to include, in this case, extreme atrocity, and they didn't argue felony murder, so I'm not going to waste the court's time on that, but extreme atrocity, you can't try him on extreme atrocity because the indictment doesn't include it.
See, we're ending at the same place. To me, you're seeking to limit the Commonwealth with regard to the theories it may pursue at trial based on a failing in your perceived failing of proof in the grand jury. It seems to me that's not a dismissal of the indictment for first-degree murder. It's a motion in limine to say that the Commonwealth can't have that evidence at trial. Even if I credited your world view with regard to that case law, that alone wouldn't result in the dismissal of the indictment because of the evidence, if I credited it, of premeditation, right? That's why I see this slightly differently than you.
Well, and I would agree with you, Judge. If you found sufficient evidence to the grand jury of premeditation and the type of malice that only applies to premeditated murder, if you find that, I agree they can. So much of the indictment that charges first-degree premeditated murder stands. But it's due process that requires this court to consider whether that indictment that was issued under the language of 265-1 encompasses extreme atrocity and cruelty, and for that matter, felony murder. And why? Because we have to be able to prepare our defense, and we have to know what the Commonwealth is going to charge, because that's the other part of this due process argument. We have to be prepared to challenge the extreme proof of extreme atrocity and cruelty, and they can't present it because the grand jury didn't hear it.
If my ruling, it ends up that the murder charge isn't dismissed, you have plenty of time. You don't have to wait on your motions in limine. You will have plenty of time to brief and address that issue between now and October. I mean, it's plain to anybody in this courtroom that knows the evidence in this case that whatever the Commonwealth's evidence is with regard to cruel and atrocious behavior certainly isn't their lead argument. It's not great.
Well,
I mean,
and
it'll be even if I allowed it, frankly, this is where I go off script. It's never good. Even if I allowed your motion or I denied your motion and said, oh no, they can go forward on both theories. As a strategic matter, they got to start thinking, are we shooting ourselves in the foot by doing so? Because from what I've seen, it's pretty thin.
I appreciate that comment, Judge. I understand you're not making a ruling, but I appreciate the comment. But I'm not going to.
But I get it. You have to get ready for trial in both theories.
And I'm going to infuriate Assistant District Attorney Cusick when I say this. I'm going to stop beating this dead horse. You and I, and Attorney Porges on behalf of Walsh, I don't think I'm making myself clear about the differences between what you're suggesting, a motion in limine to kick out a theory of first-degree murder, and what we're asking for the court to do.
You're asking me, I know what you're saying, you're asking me to dismiss it in so much as it charges cruel and atrocious.
Yes.
I understand what you're asking for. I'm not even sure, well, I'll look at your cases. I'm not even sure I've seen that ever done. It's an interesting concept. And I'll give some more thought to that if I get there. Maybe the Commonwealth will make our job easier.
It looks like they've made our job easier for felony murder. They didn't even brief it.
Right. Well, we got to start. I mean, October, TikTok, it's coming. So figure out what your theory is gonna be, and let's argue about the things that really matter, right?
Well, these really matter to us.
I
understand.
and I don't take any of this lightly. And when I say, let's talk about the things that matter, if it is the case that the Commonwealth's not gonna really pursue cruel and atrocious, then we're just wasting our time, right?
I have a brief moment to ask.
Certainly.
I think that's all we have.
And by the way, in fairness to both sides, I only know what I know. That is, I know all the stuff that I've read. I know everything that went to the grand jury. That was March 2023. What I don't know is all the stuff that's happened since March of 2023 and whether that has any bearing on the Commonwealth's ability to pursue cruel and atrocious. I don't know. I only know what I know.
Your Honor, I'm going to sit down after I say this final sentence. That makes my argument. If they develop evidence post-grand jury of extreme atrocity and cruelty, they can't just decide, oh, now we have evidence of it, we can try them on that. They have to go to the grand jury and get an indictment. And I think that encapsulates what we're talking about.
I understand the argument.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
Your Honor, the Commonwealth disagrees with Mr. Tipton's interpretation of the Riley case. Obviously, the court has it and will interpret it as the court deems appropriate. But I would suggest here that the court should not eliminate any theory of first-degree murder, because here the grand jury did have probable cause to find that the defendant committed a premeditated murder with the intent to kill. A few housekeeping matters. The Commonwealth agreed. We're not saying that we thought Mr. Walsh, or there was evidence before the grand jury that Mr. Walsh invited the New Year's Eve guest. That was Anna who invited him. The Commonwealth's argument is, with the guest being there, Mr. Walsh used the guest's presence to create a facade of a jovial, happy couple having a New Year's Eve celebration. And I suggest that that is also borne out by the fact that when Mr. Walsh eventually got in touch with the New Year's Eve guest, I think it was on January 4th, he was asked by the New Year's Eve guest, GM, well, did you argue? And Mr. Walsh's response was, you saw us, did it look like we argued? So I would suggest that that certainly supports that dinner was used as a charade. Your Honor, the defendant had serious financial, legal, and marital problems in December of 2022. There was ample evidence that he was aware of Anna Walsh's relationship with a man in DC. He's certainly doing those searches on Christmas Day. That's the day Anna had said she had to work. Mr. Walsh said that in one of the interviews with the police, that she wasn't home on Christmas Eve because she had to work. And there was certainly, she did show up late. The flight had been canceled. She did drive up, and that's the night he begins searching those WF's name online. Then later on December 27th, he's doing a search about divorce and states to get divorced in, and the results of that search shows that Massachusetts is not a favorable state for divorce. And then the mother hires the private investigator in DC. Now the mother says she got the name from Mr. Walsh, that he told her not to do it, but I would suggest here, he gives her the name of a private investigator. She hires the private investigator to investigate whether Anna is engaged in activities that are not appropriate for a married woman. And I certainly understand the court's question about the timing of those voicemails. I don't know off the top of my head the voicemails from the mother to the investigator firm, but we will look into that and see if there is anything
The one
in it.
that I'm most interested in is, well, I'm interested in whether there's a timestamp on any of them, but the one that I'm most interested in is, file 046. And in that message, she indicates, my son says, could you please check WF? Because during that period, he was in Idaho and he just wants to see how often they saw each other. That's the one that I want to know, that whether the evidence was before the grand jury as to what the time frame of that was.
Certainly, Your Honor, we will re-examine the exhibits and we'll let the court know, and we'll let counsel know, obviously, what we decipher, whether the timestamp is indeed in front of them or whether it was not. Your Honor, here, the grand jury also had information from the testimony of AK about her conversation with Anna on December 29th, I believe. They went out to dinner and she describes Anna as just being beside herself. Anna described a huge fight with the defendant over Christmas, had given him an ultimatum about the children coming to DC to live with her. She had found out that the defendant, and she does mention the lawyer also, but essentially that the defendant had engineered the children remaining in Cohasset with him because it was perceived that that would help him avoid an incarcerated sentence on his federal case. Certainly there's discussion of that during the interview with the one where the lawyer was present at, and he makes a remark about which one could infer means essentially, well, if Anna's not around, that's off the table of me going to jail. But certainly recent news to the defendant and to Anna as related through various conversations that suddenly the topic of him going to jail had arisen, and that according to AK, Anna had said he should just do whatever is necessary to resolve this, even if it involves an incarcerated sentence. So I suggest that is another, we could characterize it as a stressor, but it's also another reason why if Anna's not around, if Anna is deceased or disappeared, the defendant would suddenly be a single parent, would have the children's sole caretaking for these 3 small children. He would potentially avoid that committed sentence, which he was very motivated, one could infer from the materials before the grand jury and in avoiding. He would inherit millions of dollars in life insurance proceeds from Anna. Again, those searches also include some searches for luxury items. One could infer that he's planning to how he might spend those proceeds. And he would also...
But those searches, I don't think that rings true, because those searches with regard to in terms of premeditation anyway, the searches with regard to the watch are later.
I agree with that, Your Honor. I just suggest that...
So how does that relate to premeditation?
Your Honor, I suggest it relates to the concept of having money, which was certainly a stressor, that the defendant needed money to pay that restitution. I know at some point, I believe it was in the interview with the lawyer, forgive me if I'm mistaken, but I think it was he owed $450,000 in federal restitution. And I suggest here, the fact that he is looking at luxury goods suggests that this is, again, expecting to inherit money. Some of the searches are for cleaning up crime scenes. Specifically, I suggest that shows that the defendant's awareness that this was indeed a crime and not some sort of accidental person dying in a home. Your Honor, I suggest also that the defendant's behavior before that time, approximately 6:30 in the morning on January 1st, his behavior before that time when he says Anna left the house shows that he was planning and premeditating and had the intent to kill her. She arrived at the home on December 30th from DC. She was not scheduled to go back until January 3rd. So certainly there's a block of time where no one at her work would be looking for her. He planned to appear happy and jovial with the New Year's Eve guest. And again, when he spoke to the guest next, and the guest said, "Were you arguing?" "No, you saw us. Did it look like we were arguing?" He also told the guest that his phone was misplaced. I suggest that was also part of the planning, creating a window of time when he didn't have the phone, that it would be an explanation as to why not responding to any text messages. Certainly, how do we know this was planned? Forensic exam shows that phone was actually in motion, being unlocked and plugged into a power source when it was alleged to have been missing. So I would suggest that's another thing that would go towards planning. And the defendant, planned for
The
the,
fact that he shut off his phone or he put his phone, the phone that's missing, let's even make the most adverse inference to the defendant. That all happens after the Commonwealth believes that he's killed Anna, right?
Your Honor, he tells the
So
New
this
Year.
rearward-looking concept of premeditation is a little bit difficult for me to
Your Honor, there's testimony
appreciate.
from the guest on December 31st, before Anna had been killed, that the defendant said his phone was mislaid.
All right, you're right.
So certainly the phone disappeared or was mislaid or whatever happened to the phone, but the defendant represented that his phone was mislaid on December 31st when the New Year's Eve guest was there with Anna. And the defendant also, there was a nanny coming that afternoon. She was scheduled to come about 2 o'clock on the 1st. Anna had told a woman in a nail salon that she and her husband, the defendant, were going out to a adults-only dinner in Marblehead. And certainly I'd suggest that there's no other evidence of that other than that statement. One could infer that the defendant told her that they had plans to go to this party in Marblehead, and that the nanny was going to be there. This would give the defendant, again, a window of time to take action to deal with the disposal of the body of Anna Walsh. Certainly from WF's testimony, it's clear Anna had no plans to tell the defendant about their relationship over the Christmas holiday. She said that he would be devastated, and she also said she did not know what he was capable of. And one can infer that the defendant certainly was seeing those text messages, whether he looked at the phone itself. He made some statements in the police interview of claiming that Anna had put the phone upstairs based on a message from someone named Abdullah that had caused some controversy. Certainly the GM, the guest sort of contradicts that, saying she was using the phone throughout. And other people, AK was receiving text messages from her, and she was texting with WF. Certainly it's a fair inference that the defendant saw those text messages and perhaps realized the true extent of this relationship that they were having, where they were discussing long-term plans, 1, 5, and 10-year plans, and there's a reference to travel that they had taken together. That it's fair to say that the defendant, that might have been something he didn't know about, because based on what at WF's testimony. And also WF, Anna sent a photograph of the house guest herself and the eldest son to WF. And that was something, again, that Mr. Walsh told police about, that she had sent that to him. So I suggest that certainly there's a very fair inference.
Play that again to me, that last statement.
During one of the police interviews,
Yes.
the defendant says that Anna had taken many photographs during the evening and had sent one of them to WF. And that's in, I think it's the third interview, the second or the third interview, Your Honor. And certainly I can find a page site for that.
Thank you, I appreciate that.
And Your Honor, I'd also, cases I'd call the court's attention to are Nadworthy, which is in the Commonwealth's memorandum. It's 396 Mass 342, and Cardarelli, 433 Mass 427.
Can you give me the second one again, please?
433 Mass 427.
Yes.
And these cases indicate that, in some circumstances, evidence of a defendant's activities afterwards, after a murder is committed, can be used to infer motive and malice. And I would suggest here the defendant's activities of looking up how to clean up a crime scene, his activities of purchasing large quantities of cleaning supplies in various stores, and certainly going to different dumpsters and disposing of, one could infer, the victim's body in her possession, certainly is indicative, should be considered as consciousness of guilt, but also as evidence of intent and motive. So, Your Honor, the court has all of the materials that were presented to the grand jury, the exhibits, which are voluminous, and the transcripts and the memorandum from the Commonwealth. If the court doesn't have any other questions, I would rest on the pleadings. If Your Honor does have questions, I will get the answers to those questions the court does have to the court.
All right. I don't have any questions.
The Commonwealth would ask the court to deny the motion in its entirety. Thank you.
Well, let me add, I do have a question. Attorney Tipton is suggesting that I have the power under the law to sort of slice the bread, slice the loaf of first-degree murder, such that I could dismiss the indictment in as much as it charges cruel and atrocious. And you haven't talked about that.
Your Honor, I disagree with Mr. Tipton. The Commonwealth does have, there's very few cases on this that the Commonwealth could find. There are 2 unpublished ones in the Commonwealth's memorandum that deal with dismissal of so much of an indictment as charges first degree. I'm not sure if they split it so much as to theories, but I would suggest looking at the Riley case, it's clear that if there is evidence to support first degree murder under any theory, then
survives.
It survives.
The indictment survives.
And the Commonwealth may proceed at trial under any theory. Again, it would, and they also mentioned
any limitations that might come as a result of the motion.
Again, and I believe that it might be in a footnote, but there's reference to subject to bills of particulars or turning over evidence or information like that. It's not vastly, it's not any different than other rules.
Do you want to discuss what evidence the Commonwealth believes was before this jury on the theory of cruel and atrocious?
Your Honor, I agree with the court's description of it as thin. I don't disagree with that. Again, I would suggest that at this juncture, the court should not cut any theory out of the indictment and should instead, again, I imagine this will be litigated prior to trial. But the Commonwealth, again, if the court finds that there was sufficient evidence of premeditation, this juncture is not the time to make any determination as to what the Commonwealth may or may not do with other theories.
All right. I appreciate the argument on both sides. Attorney Tipton, it's your motion, so you get the second bite of the apple.
It'll be small, but because I'm not going to repeat what I said, but ask the Commonwealth judge, if you will, give you one citation for a case that says a trial court does not have the power to limit what can be tried based on what's presented to the grand jury. Those 2 cases they talk about, there's actually more, but I think they're talking about Johnson and Rivera, which were 128 decisions. They don't have any reasoning or rationale to them. They don't explain it. What we do know is that there is a whole body of case law where the court examines what evidence was presented to the grand jury to determine for the appellate court's reasoning that there was sufficient evidence in light of a motion and in light of a ruling by the judge that there was insufficient evidence, and so you can't try the person on a particular theory of murder. I can give you the citations of those cases if the court permits, but I don't think the government here, and they have 2 well-versed appellate attorneys with them, can give you one citation to a case that says, you, judge, don't have the power to do what we're asking you to do. And of course, what we're asking you to do is we believe is grounded in.
All right, well, I'll give you a couple of days here or there to bring me up to speed or give me any citations. Obviously, you don't have to file a pleading. Just need to memorialize it and emails to each other that the cases that you're bringing to my attention. If you prefer to file a pleading, that's fine too. And if you give me case law, I'll just note the emails and put them, I'll just have them scanned or something so that there's a record of it happening if you need that.
I will file a very short pleading.
Whatever's easier for you. All right. So that matter's under advisement. Now, so let me say that I was happy to see you all on the Zoom with me last week because we were getting the same information, although I think you were on a Zoom that I was not on because I did not get on the Zoom with Judge Krupp round 2. The reason I didn't do that. And I apologize, by the way, if you didn't get notice that the 3:15 hearing that I had preliminarily ruminated about got canceled. I don't know if you were on there. I think what happened, honestly, and I don't want to throw anybody under the bus, is that a couple of clerks in Middlesex, in Norfolk were out in the afternoon. And so it was a slip stitch between what was probably apparent to you that by virtue of what had happened on Friday, we didn't have an emergency situation, although some could argue otherwise, and did on Friday. I understand from listening to the FTR. But regardless, it seems to me that we have a slightly different situation than maybe we have a different situation than what presents in some of those other cases. And here's how I think it might be different. Maybe I've got it wrong. But let me just start the discussion in this way. It seems to me that ADA McLaughlin is one of the signatories on the agreement as a result of being on the Reed case. And it seems to me that she is on this case, was in the grand jury throughout the 11 or 12 days of the grand jury. So she's intimately familiar with what happened in the grand jury. And otherwise is intimately familiar with what this case is about because she's still on this case. And being in that unique role as being A, someone who can look at the materials, and B, is assigned to this case, it would seem to me that she would know whether or not there were any materials that were required under Rule 14 and the case law to be produced in this case. And that situation does not replicate itself in all of it. I don't know if it replicates itself in any of the other cases that people were involved with Judge Krupp last week. I don't care about those cases. I just care about your case, this case. So it would seem to me that with that pause, I understand that Judge Casper has put a 30-day pause on everything for people to assess the situation. And it seems to me that what needs to happen is that ADA McLaughlin, who has access to that information, needs to determine as an initial matter whether there is anything in those materials that would be required to be produced under Rule 14. And if there are, we'll deal with that. And if there aren't, then the Commonwealth needs to aver by, think of a bunch of different ways, affidavit or otherwise, that there aren't any. Now, the backdrop to this is, as we know, and I'm not going to get the exact language correct, but when we asked for a TUI request earlier in this case, we're not giving it to you, but by the way, there's nothing there. That's my paraphrase of it. But that doesn't relieve the Commonwealth of its obligation. So that's how I frame the issue in my mind right now for this case. And I guess it's the defendant's motion that brought us here and alerted me to the issue. I mean, the Commonwealth gave me an email before that, but Attorney Tipton, what do you think about that first shot? Attorney Porges.
So I had a brief discussion with the Commonwealth this morning, and my understanding is that they're filing a request to impound the protective order in which they would show it to the court, show it to us.
They did.
Okay.
Did you get that before the hearing?
We did. So we have the protective order. So our main concern this morning was asking the court to order the Commonwealth to review the material for any exculpatory material or issues. If the court's inclined to do that, then I don't need to be heard further. I would just highlight that a case came down just yesterday that is decidedly on point with this issue. You're smiling because you know you're smiling because you know.
I think I know.
Okay. It's Commonwealth versus Gokarian, and I would refer everyone to the section that discusses possession, custody, and control. Furthermore, the new revised rules under the Mass Rules of Criminal Procedure do a very good job of clearly explaining and expanding what exculpatory means. And in this situation, they are arguably in the possession of federal grand jury material that was investigating not only Trooper Proctor, but possibly the integrity of a murder investigation done by this very county, by these very officers. And so I just want to be clear that if the court is going to order it and the government is going to accept the order, that we want to make sure everyone has the same understanding of what exculpatory is. So otherwise, I have nothing further unless the court has any questions.
No, although, let me see if I can get to that paper. So I like to take things very, very logical person, I like to think anyway. So I like to take things step by step. So we'll just go in that manner and we'll cross each bridge when we need to.
Okay.
But I know two particular parts of the order that got my attention.
So when you say order, do you mean the protective order or do you mean the motion that Mr. Tipton filed?
The protective order. And one is paragraph 14, which may bring you somewhere else. And I'm doing this to put, I'm putting the high beams on for your future, should we need to. Paragraph 14.
I think that's a bridge we'd have to cross.
Yes, and
at one point.
yes. And the other paragraph that stood out to me as having relevance to this issue is the opening sentence or all of paragraph 11 with regard to the issue of possession, custody, and control.
The first sentence of paragraph 11?
I think it might be one, yeah, yes. But we don't have to,
I don't think
I'm just alerting you to those two paragraphs because they're two things that caught my attention as we move forward on this issue. But let me hear from the Commonwealth first with regard to
okay.
what, and then I'll go back to the defense. Thank you, Attorney Burgess.
Thank you, Your Honor. So it's kind of a unique posture because my co-counsels are not party to viewing the protective order at this juncture. So First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does
Attorney General.
supervisor mean?
That would have been the chief of the appellate unit at that time who signed the protective order in 2024.
But it says, is that right?
That was the way.
Hold on a second. I just want to go back and see what the. So I refer you to 6B. What does that mean?
When that was drafted, it was relative to supervisors assigned as part of the Karen Reed prosecution.
Right.
So at that time, it was the First Assistant Lynn Beeland.
But it wasn't just appellate supervisors.
Correct.
And
Correct.
supervisors of council of record. So anybody that was council of record supervisor, which could be multiple levels. I don't really know. I haven't studied your corporate structure.
Correct. But as I can say today, well, defense counsel has the opportunity to review the protective order. My co-counsels have not had that opportunity. So Lisa Beatty is in contact with the Special Assistant Attorney General who has an update. She's on Zoom. If your honor would like to hear from her, where the office is working with the U.S. Attorney's Office about any future amendments to this protective order or any additional clarification that the office is seeking about any potential further disclosure. So if you would like to hear from her, she is on Zoom and could fill the court in on recent updates that occurred this morning.
Yes, please. Welcome, ADAB. I can't hear you. Hold on. Can we try that again?
Can you hear me now?
Yes, I can, thank you. I can't see you anymore, but I can hear you.
Can you hear me now, Your Honor?
Yes, and I can see you.
Okay, great, thank you. Your Honor, I'm in the process of drafting my notice for Judge Kruk, which is due in 18 minutes. And I got a call from our counsel informing us that at this time we will be able to view the protective order. I know that not all counsel, not all assistant DAs in the office have been able, and I have not been able to view the protective order until I just learned this information. So I can't speak to what's in the order. So that will be able to be changed if there are ADAs who have matters that are in the posture that we are providing discovery and need to address these issues. ADAs will be able to look at the order. In addition, defense counsel, after the state court and defense counsel have signed a protective order, defense counsel will be able to have a copy of the July 21st order as well as the December 2nd protective order. Those are sort of my updates as I'm receiving them now. And then the U.S. Attorney's Office has acknowledged that we need additional accommodations or modifications. I don't know the exact words that they would use, but we have additional requests in order to be able to move forward with cases in a productive manner. And they understand that we're going to continue to engage in dialogue with them and possibly the federal court about how to manage these situations.
All right, thank you for the update.
Now, just add, the case that came down yesterday is distinguishable because in that matter, the SJC said that the DA's office did not have those materials, that federal materials in, perhaps a protective order remain in the custody of the federal government. That case is distinguishable because a Worcester police officer participated in the interview and had personal knowledge that he could have discussed or disclosed to the ADA, that the ADA did not pursue that information that would have been held by a Worcester police officer. It is distinguishable that pursuant to this order, the materials do remain in the care, custody, control of the federal government, and the DA's office is just prohibited from any further disclosures.
So what of my suggestion with regard to your role?
That is a role I understand. That is a role I can represent to the court in a different matter. Upon my review of the materials, I saw a statement that was very late exculpatory in a different case. I spoke to the U.S. Attorney's Office about that matter and had to advise defense counsel and trial prosecutor in the office that they needed to seek a TUI request. Right. I could not disclose that directly. The U.S. Attorney's Office did not produce that outside the protective order. Defense counsel and the Commonwealth had to seek that information. I provided date stamps, numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
And that, I would say, has been done, and it's sort of in the similar posture where we represented to counsel that you need to file a TUI request. Counsel filed a TUI request, the Commonwealth filed its own TUI request. The U.S. Attorney's Office denied that.
But the difference is, in the other case, you identify a document that you believe. What I'm asking the Commonwealth to do, and I'm asking you to do it now in light of the new rules of discovery, not the ones that may have applied when you did it the last time.
Yes,
is to review those materials and identify whether we even have something to worry about.
And the understanding would be trying to, without knowing the defense theory of the case and seeking the broadest, what is most fair to the defendant.
That's always your problem. I don't mean you. It's always the prosecution. That's, I mean, they make that argument, I don't know, a couple times a week before me when I'm sitting in a criminal session. They can't possibly do as good of a job as me. And yet you have to. That's what the rules require.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where if there was a matter, I cannot disclose it to defense counsel, and I cannot disclose it to the court.
I understand that. I understand that, but why is it not, say easy first solution. It puts a huge burden on you. I don't know how much materials there are in there. But why isn't it the first step that we should be taking here is we have somebody that's assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you have knowledge of this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours, for you to make that analysis and at an initial matter say there is or is not something in the materials that we need to disclose?
And I can represent to the court that the materials that were produced are related to the investigation of the death of Johnny Keith and not any materials related to the investigation of the death of Anna Walsh.
All right. Well, I appreciate that. That falls short of what I'm asking you to do, which is to avert to me, probably by affidavit, that there is or there is not information in. I understand their focus was on there. That doesn't mean that something doesn't make its way in to that file and those records. And I want some assurance that somebody has laid eyes on those documents and recognizing that it might be unlikely that there's anything to do with this defendant in those records. Close that door.
And to do so, Your Honor, I believe we would have to seek guidance from the U.S. Attorney's Office to make sure it's not outside the confines of the protective order. Because the way the protective order says,
well, the
you know,
order
summaries
allows you
and
to
things
review
like
it, right? The order allows you to review those materials
for use in the state court action against Karen Reed.
So have you sought guidance from the court with regard to for review in connection with any other cases?
I believe that is what ADAPD has represented with, where the Commonwealth can't represent itself in federal court, a assistant attorney general has been appointed, and I believe there's ongoing discussions.
All right. Headed to another meeting on this probably next week. I don't want this to, I'm not going to put this out till the 30th, the 30 days, and we're in another fire drill. So we'll talk about that.
Your Honor, just briefly, I'm certainly sympathetic to the position that ADA McLaughlin finds herself in. It's clear that she understands her obligations under Rule 14, under Brady, but I do disagree with her analysis of Goparian. When it talks about reviewing material, the detective in Worcester was a detective on the homicide case in Goparian. And so just for a picture, ADA McLaughlin is an ADA, part of the prosecution team in this matter. The cop in Goparian randomly happened to be present for a proffer on an unrelated case in which someone made a statement. So Goparian went on to specifically state that the law demands at the very least that the prosecutors ask other members of the prosecution team whether exculpatory information exists. So to me, that combined with Brady and combined with Goparian impose a duty for her to look. I understand that she is, and I agree, the 2 paragraphs on the protective order, I think, are very clear, but I don't think it's an automatic, just automatically resolves her or the rest of the team to just not look because they can't. So I think it's a long way of me saying we might have to end up litigating something in federal court. And so I think we do need to kind of figure if the motion, the protective order can be expanded insofar as ADA McLaughlin has to do a specific root review for this case, guided by the revised Mass Rules of Criminal Procedure, Section 14, that gives a very clear description of what in fact is considered exculpatory.
Your Honor, may I be heard briefly? Yes. I apologize for interrupting. These are exactly the issues that we are in communication with the U.S. Attorney's Office, and I can promise the court that I can address this specific case and this specific request that this court is making at this time when I speak with them. Right. If you would give us some additional time.
I will, and I appreciate you specifically raising this because I think we have, I don't want to get, particularly in light of the schedule in this case, I don't want to get dragged down with the other cases that are not in a similar posture. The unique situation here is that A.D. McLaughlin has already seen the materials. It's not disclosure to any, she saw them in connection with another task, but it's not like a new person is coming on or a new set of people are coming on at this moment. So that might give us a swifter direction to a better result. So I'll give you some time to see if we can sort that out.
Thank you very much.
All right. So those are the motions that we had to hear. We're going to set a status on this last issue for next week. Clerk, what do we have?
Judges, we're picking this date. I'm just hoping we can appear by Zoom. The Porges is going to be, Attorney Porges is going to be on trial, and I'm on vacation, but I'd like to appear by Zoom.
Yes. You're welcome here, and you're welcome to appear by Zoom.
Thank you.
So, now, Clerk, what is our next one?
If you're willing to, I'm sorry, Madam Clerk, if everyone's available for 2 or 3 p.m., I might be able to get permission just to hop on at 4.
Okay.
But if I might not, I'm just throwing it out there.
Is 2 or 3 p.m. better?
Well, I don't want everyone to schedule around me. I mean, I do, but I could be in the middle of a witness and the judge is like, I can't let you.
Right.
But it's just, there's a higher likelihood.
Well, why don't we schedule it at 2, knowing that probably somebody could, I don't know who you're before, but they might be able to take another 10 minutes.
And he's lovely. I'm sure he would. I just don't know where it may.
So Friday the 1st?
No, any day but Friday.
Oh, any day but Friday. Sorry, I apologize. The 31st, is that available?
We can do Friday the 1st.
Whatever works for the court.
So why don't we do Friday the 1st at 2 p.m.?
Friday the 1st at 2 p.m.
Can I trouble Madam Clerk to issue a Zoom aid to Norfolk for Mr. Walsh?
Yes, I'll request it through the Norfolk County Clerk.
Thank you. Oh, I'm sorry. I can do that too.
That's all right. We'll be in contact with them.
Thank you.
I have to whisper. I have to whisper because people got headphones in. I have to wait for them to turn it down. Wicked Psyched has got headphones in. Hello? Hello? Just waiting for confirmation. Oh, we're fine. Wicked Sykes said it's fine. So there you go. So that was it. I mean, that was the gist of it. We saw both. So, okay. No, it's fine. If people tell me I'm normally pretty good, I just don't know always that I'm too high. Do you know what I mean? Dave, I thought it'd been funny seeing you run. Flat on your ass, probably. But yeah, I'm out of touch a little bit with Brian Walsh, but I'm looking forward to catching up with it. I should be out in Boston if it continues, but if they do relocate, I might not be going to it. But if you're still in Norfolk County, I might try and pop in for a day. I'm not sure. We'll see. Because I'm going to be busy with other stuff. So we'll see. I probably won't be around for this trial, as in online, but we'll still stream it. We'll still stream it for sure. So it'll be a place for people to come, you know, and all that. What do you think about today's hearing? Do you think they will change things up? So there's a bit of confusion. Hippie Chick was saying, I had an offline conversation with Hippie Chick. She seems to think Melanie Little saying that it's the judge is not recusing himself from the whole trial. It's just on one portion of the trial. which might be true. I don't know. That's not exactly. But again, I'm out of sorts with this trial, so I'm not 100% sure. But the relocation of the trial, I'm not sure if they will allow that or not. It's pretty last minute. But they may do. They might move it to Plymouth. I'm not sure where they want to move it to. So we'll see with that one. I know they've ruled on a lot of motions as well. I think most of it's allowed in now. So I think the search and stuff allowed in. That's what it sounded to me was regarding that. Yeah, the problem I got is I don't know enough. Like the one topic people are saying, I didn't realize there was about one topic. That's how far off I am knowing what's going on with this trial. So I was going into it thinking they were talking about the whole trial, but yeah, you're probably right, J-Mac. I'm just out of touch with this. I have not even watched this hearing before now, just been doing other stuff. I like the judge. It seems that she can rule fairly and is transparent with her decisions. I agree. I like that they talk openly. I still don't understand why it's in Plymouth when it's Norfolk County. So it's Plymouth because she is based in Plymouth. So I think these are done in Plymouth because she's based there. Judge Bev initially had this, and she's obviously in Norfolk County. So I think it's all marked to be happening in Norfolk County, but the judge itself is based in Plymouth. Hence why they hold most hearings, I believe, in Plymouth. Hi, Colton. Hope you're swimming well. Hope you enjoy your swimming, Colton. Hope it's not too cold now. Hope you enjoy swimming. Swimming's good for you. Good to learn swimming. No, we could say I agree with you. I like when they talk openly about stuff and ask questions because I think you learn, and I think that offers a lot of transparency. I think you can see both sides had to really think and answer her questions. So yeah, I like that. The crime occurred in Norfolk County. I'm not sure, but the trial is scheduled for Norfolk County. The pre-hearings don't matter. I mean, it doesn't matter when they're held, as long as the jury and the trial itself are held in Norfolk County. However, they may say, no, do you know what, we want to do it in Plymouth. So I have no idea. But as it currently stands, the trial itself will be done in Norfolk County, but it doesn't matter where the hearing is done. Essentially, who cares? It could be done on Zoom, the whole thing. It's more just about where the jury pool will come from, and currently it's going to be Norfolk County. So we'll see. But he might say, no, I don't want it there. I want to move it to Stoughton, Plymouth, or whatever. I don't know. We'll see. It's good. There you go, Colton. Now, Colton, you're going to help do some cleaning. I think Mum needs some help cleaning. So yeah, the judge seems fair and like she's not an ego demand. Yeah, Lou, that's important. If you haven't got an ego, then I think everyone respects you a lot more. And again, she hasn't got an ego because she questions stuff publicly, and she's like, "Tell me this. Why this? Why that? Do you think I can legally do this?" And she's looking for opinions, and I think that's a sign of a very self-assured person. Self-assured, and just be like, I'm self-assured of my own skin that I can actually ask these questions publicly and entrust the public that I'm being transparent. And it gives both sets of attorneys the knowledge of where she's leaning, where she's not, and how to, she's giving everyone the opportunity, which I like. She's not just doing a ruling, listening and ruling, and that's it. And no real rhyme or reason about why she's done what she's done. No, you will. You might get $5 or $10, Colton, if you really, you never know. Get cleaning, son. You might get some pocket money. So yeah, I don't know. It's going to be interesting, I think. As I say, we will cover this. There's lots of trials coming up. So Aaron Spencer is now, both sides are asking for, Lady Di said both sides are asking for continuance. So that will probably be continued to later on in the year. We got Lindsay Clancy. Interestingly, lots of people are not really into Lindsay Clancy. She is the mother that killed 3 of her children and had a psychotic episode. I think that's a very sad, obviously sad trial, but very interesting trial, I think, because there's a lot that goes into it from a psychological point of view as well. So she obviously tried to kill herself as well and stuff. So yeah, I'm that's going to be a very sad but very thought-provoking one, I think, trial. So I'm actually looking forward to that one because it's going to be a tough one, I think. So so I want to cover that more in depth. And she's got a very, very good attorney, Kevin Reddington. I think because we haven't heard much about Lindsay. True, I need to do more about Lindsay. I do. It seems that everyone's waiting and waiting for Brian Walsh and then stuff, and then we'll jump on Lindsay Clancy. Whereas maybe I'll go in now because it's as I say, it's a very, very sad case. Especially when you got children involved. But it's very important. Postpartum psychosis is real and not treated properly, and it's something I'm not really used to. Do you know what I mean? But we got Lou in the chat. Lou will understand a lot more about that kind of stuff than I do. But I want to learn more about that because it's real life. It's, as you say, J-Mac, it is real life. And it probably happens a lot more that we're not aware of. So I think it's an important case. Obviously got the trial on Monday we're doing as well. I don't remember his name, but we're doing that next week. We'll do a deep dive Monday for that one. Brian Walsh, 20th of October. Courtney Clenny, 19th of December. Erin Hack tells me Shana Gardner and Mario Fernandez was scheduled 20th of October, but might be pushed on. So we'll see about that one. And we got Lawrence Doherty, his sentencing on August 29th as well, 11 a.m. Eastern. So Lou says, J-Mark, 100% agree. Women postpartum can be very vulnerable and need specialist care if they develop mental health problems. There you go, Lou. There's a few people that I look at from a psychology point of view. We've been quite lucky with Lou, and there's a couple of others that do drop in, as well. What do you mean? We'll see. I know. Erin, Golly. Well, so on the docket, it still says 20th of October, Erin Hack, is why I'm questioning it, So maybe you're right, but it's on the docket still 20th. So I've learned not to question you. Wicked Slice said, my tomatoes are quite happy and productive too this year. Oh, nice. Grow your own tomatoes. Happy days. Good for the docket. Oh, no. When I say docket, not the docket, but the court docket. So you send me the info when you know it, when the trial goes ahead, Erin. I believe you. Courtney Clenny will be shown. What's the other one called in Colorado? Or was it Colorado? Or was it Utah? The one that wrote the book. The one that allegedly killed her husband and wrote the book. Have I got anything? I don't remember what she's called. I think she starts with a C as well. Corey Richards. You see, she comes in. The hackster comes straight in. Corey Richards. I'm not sure is that going to be streamed. She's cooked. Yes. You see that one. You see, she's cooked. What everything's seen, she is cooked. So things like that, I don't really like to cover. Same with Sarah Boone. I didn't like to cover that. I didn't cover it because, like, you just know there's video evidence for she's guilty. So I'd rather cover those that need covering, even though they're not popular. Thank you, lovely. J-Buck says, I agree. Lou sounds like they just kept throwing meds at her and couldn't get it right. So sad. Well, it is a case I'm going to delve into a little bit more. Definitely. They added on like 20 more charges. Oh, is that in February? Yeah, I don't think is it streamed, lovely. I don't think it's streamed, is it? But I can tell you in February 9th is Lindsay Clancy. And I will confirm now this channel will be covering Lindsay Clancy and not Corey Richards if it is streamed. I think that Lindsay Clancy stream is, for me personally, about 100 times more important than any other case. So August is sauce making month. Oh, make your own sauce of tomatoes, nice. Okay. Recovery Addict is on it, trying to get in the courtroom to be able to stream and share. Oh, cool. Yeah, they're quite funny over there, aren't they? They're very funny about it. And every time they do a hearing, it's like on a half-hour delay and stuff. But if it's in February, I won't be covering it. If it's clashing with Lindsay Clancy, I would rather do. I think the Lindsay Clancy one is the one we did a poll yesterday, and it was the lowest voted one. So I don't think it's going to be a popular one. I don't think, according to the poll, people want to watch Donna Adelson, and which is fine. But I think Lindsay Clancy is more. It's something I really want to cover to bring some awareness, and also obviously to highlight the 3 children who lost their lives as well. That's why it's going to be difficult as well, because of the children. So then there's other stuff like Mickey Steins and stuff like that, but that those are in the future. Sarbood trial was a great study in grandiose narcissism resulting in a life sentence. I think I like the build up to it, Lou. I didn't want to. I will be covering Donna. I will be covering Donna Erin Hack. Don't worry, I'm covering it. But what I'm saying is, it's not important to me, Don Adelson. It's not. But I will be covering it, and I need you here because I know nothing about this trial. I didn't want to watch it, Lou. It is a conflict between Sarah Boone and something else. I don't remember what it was, but there's another trial happening or had happened or something. And to me, Sarah Boone was just slam dunk guilty. But I did enjoy watching the hearings though, and to read about her filings and stuff. I'll give you that. It's just the trial itself. I was just like, don't really care. Boone made me simp for the state, Lou. I felt dirty. Oh, you watched Catherine and Charlie? Yeah, I've not watched any of them, Lou. Hack. So I might have to do a trial. Not trial. I might have to do I might have to do the Charlie one. Just do that trial again. I might do that. I've never watched it, so I know nothing about it. So I might do that. I might talk to you offline, Erin, and see. Might do a zoom of those trials in the lead up to Donna. I think she starts on the 19th, but I think it's jury selection and not actually the trial. So that's what maybe I will do. I do as well, the Wicked Site. I do as well normally. I think there's a lot of interest in the Don Adelson one, which I'd not jumped on board with them at all. So the one on Monday we're doing is going to be a low profile case. I don't think many people know about the case, but obviously people will stream because it's on law and crime. But it's not a well-known case. Brian Walsh will be well known, and as I say, I probably won't be here to cover it, but we will cover it. And then Lindsay Clancy is definitely one I want to cover. So we'll see. We'll see how it goes. But you know what it's like with me. I just jump up or jump down. But I think a lot of people want to do Don Adelson, and I think that because I don't know anything about it, and there's no real interesting cases, I'll do that. Have you heard? If you want to do a research, Doctor, yes, right, Doctor Who's. I know, I will try and do it. But what I'm trying to do though is, if we're doing Don Adelson, I need to build up to it because I literally know nothing about Charlie. So I'm not sure. Is it worth me doing a retrial of Charlie or not, Erin? Basically, I don't know. Or is it just worth going blind to Donna? Jen Soto, I've not heard anything about Jen Soto. Lovely. Not heard anything about her, to be quite honest with you. Boone could have got off with manslaughter. She was off. Was she off for 10 years? And she was already in for 4 or 5 years. Or was it 15 years she was offered? It was something that she'd be out fairly quickly, but it meant that she couldn't sell a story or something, wasn't it? She had to really admit to it and then wasn't allowed to profit off it, which she was never going to do. I almost didn't listen to Dorothy case because it involved a known person. Oh, okay. That's interesting. I only listened because he covered it. Oh, thank you, Wicked. It was interesting. Yeah, it was something that I had found, and I was looking at it going, I'm not sure. I honestly thought loads of people were going to cover it because it was popular. I was really surprised that no one really was. So it was a slam dunk for me to be like, oh, okay. I didn't expect to cover it. I thought loads of people were going to cover it. So, you know. But I'll tell you one thing. I'll get to it now. Okay, maybe we'll do Charlie on the stand and Wendy. Okay. Well, we'll get a list together, Hack. Okay. I've heard about Transotto, Sports Stars Hollywood. So, I agree to a very strong degree. I agree with you, Wicked Side. It doesn't really attract me either. We did do Alec Baldwin, but that was more because nothing else was on. But we did an NFL player. We did Travis Rudolph. He was known. I think it was only me and Bradley Church were covering it, and that was one of my favorite trials. Oh no, there's more covering it, I think. But like myself and Brandy had full access to the family. That's when they sent me shirts and stuff like that. They were great. Hey Rhonda, how are you, my darling? Nice to see you. Thank you for watching the other trial. I appreciate you. I don't know. Yeah, I think he wants another trial, Lou, but I don't think he's getting one at the minute. So Travis Rudolph was a great trial. But overall, I tend to agree that high celebrity ones, like for instance, Johnny Depp, I never watched. I watched a retrial of it one Christmas because people wanted to, but I didn't get into it. I didn't enjoy it. It was not really my cup of tea, which everyone started screaming at me about because it's like, wow, it's Johnny Depp. I'm like, yeah, but it doesn't really fulfill me. So we'll see. They are going for her last because the boys are old enough now. They do not want to leave those boys without a parent, but that is just me. Oh, okay. Yeah. So I think it's, when it comes to celebrities, I think it's choices. It depends what it's going to be about. You know, as I said, I did not enjoy the Johnny Depp one. There's a couple of others I did not enjoy. I actually did Gwyneth Paltrow, which I did enjoy. Civil Case, I actually did enjoy that. So that was actually quite good. That was one of my first ones actually, and it was really really good because it was about her being sued because the guy said that she injured him on a slope somewhere, and that was really interesting. Really interesting. But yeah, on the whole, I'm not a massive celebrity one. Like P Diddy, I don't really. I haven't watched it. I've watched nothing about it. You know, so. Yeah, do you know what? Lovely. I am in the minority. I didn't watch it when it was the UK trial. I didn't watch the American trial. Just not my cup of tea. You know, I've watched it because I had to do a replay for everybody, but. I am very much in the minority, Lovely. I get it. It just wasn't. It's not my kind of trial. And yeah, I love Amber Heard, as you know. Love Amber Heard. No, I don't love Amber Heard. Before everyone starts on me, I just don't get it that she shouldn't have let the dog shit on the bed. She shouldn't have let that happen. I thought that was bad on her behalf that she left the dog on the bed to shit on the bed. So he lying. So I'm just waiting for the uproar. Just waiting for the uproar, yeah. But the dog stepped on a bee. She was being nice. Oh, yeah. Well, this is the thing. She's a lovely person. Do not fall for this. Erin Hacks is trying to get me into trouble right now. Maybe if I watched it live, maybe I would have enjoyed it, but I did not enjoy the replay of it. I was just sick, and I was like, get me out of here. I'm a celebrity, get me out of here type of thing, So yeah, we have all that. I don't know what else. What is the trial I'm covering Monday before I... Yes, so it is the GA. What's that? Georgia. Is it GA Georgia v. Nicholas Cassotis? Jury selection is on Monday. Cassotis is charged with the murder and dismemberment of his second wife, Mindy. The YSL attorney, who again, YSL was not something I ever watched. I had no interest in it. Douglas Weinstein, or Werns, whatever you say it, is representing the defendant. So that's the trial we got next week. Yes, so that's what I'll be covering. So that's a bit of an unknown. I like that kind of stuff. Everyone's going to be streaming it because there's no other trials on at the minute. But that's what I'm going to be streaming. I'm going to be researching all weekend. Not all weekend, but I got my little niece this weekend, so I'll be researching as much as I can. So I've got a little terrier, 5-year-old terrier this weekend. The whole weekend. Oh, jeepers. But yeah. I will research it. We'll do a deep dive on Monday about that case. So maybe 2-3 hour deep dive, and hopefully starts on Tuesday or Wednesday. Hopefully. J-Mac says, I literally know nothing about the JD trial. You're lucky. You're lucky. Lucy, I think it was the Gwyneth Paltrow trial when I first found you. Was it? Oh, there you go. Yeah, because you're old school, Lou. You are old school. So yeah, you've been here. You're probably like top 5 member. So yeah, you've been around. So yeah, it would have been, but that's a long time, Lou. That's a long time, Lou. And you still stuck around. So good, J-Mac. Amber Heard should not have pretended to be heterosexual to bag a megastar. There you go. That's true as well. Or you'd be busy. I will run my parents are helping out as well. It's not just me. My parents are helping out. So, but yeah, she's coming over 5 o'clock tomorrow night. And she wants, well, my mother, her grandmother's cooking. So she's already put her order in. She wants turkey burger and chips, which is turkey burger, these thingies, and fries, as you Americans call them, and baked beans. That's what she wants. Then we're all going shopping on Sunday, grocery shopping, and she wants McDonald's for lunch. So we go in for that. And then whatever, then in the evening, we got all day. The rest of my nieces, my sister and her fiance, they're going away for a couple of days because my niece, my eldest niece, has won an award. So it's just nice for them to, my little niece, I love her, but she gets all the attention, do you know what I mean? So, or she wants all the attention. So it gives them all a break, so. And my eldest niece starts university this year, so it's nice for them to spend some time together. So I'll be knackered come Monday. I was watching the LG Fake Victim court this morning on Judge Cut. I saw that Mike put a stream on. So a few people streamed. I think Kelly and Amy were streaming as well, and the judge kicked everyone out that did not have permission to be there. And I think Mike's pissed. From what my understanding is, he's pissed. So we'll see. I've not watched it. I don't really know what happened, but and he's done a stream about it. He's discussing it. So Lance chats can have conversations. They don't always agree and remain respectful. No one demands someone to be removed for a different opinion. No, do you know what? Some people get offended. I will say this, Wicked. Since I've been doing this, I've learned people get offended real easy, and some people will stay, and then they'll get really offended on something, and then they'll leave, and then never come back. And I'm like, if that's the caliber you are, then I don't want you in the first place. You know, I also recognize that some people will get really into something and maybe for a split second lose their shit, you know. And I'm always a forgiver of that. And I ask people to forgive because sometimes the mods will time you out. Don't get pissed off if you get timed out. Like we used to time out Die the Druid all the time. And I like Die, but he used to go fucking full throttle. He disagreed, but I was like, Die, you got to stop that. So we time him out. He come back and he's calm, you know. So I think on the whole, we really encourage people to have an open discussion. But I also understand that sometimes things will get heated. And that's when I try and make sure people just try and realize and step away. Or if it does get heated for like a few minutes, just chill. Just chill. Don't take offense to it. Just chill. And that's it. But some people really get offended. And if they do and leave, then they do and leave. You know, I'm not a babysitter at the end of the day, but I really do encourage it. And I don't want people to be abusive, but I do understand also that it can get heated at times. And you will get a warning for it, you get timed out, but after that, then if you continue it, fucking, you're gone. Do you know what I mean? It's not worth it. If you can't have a respectful conversation, it's not worth it. Just go somewhere else and abuse people. You know what? There's no point. So, no, we try and keep it. As I say, we understand sometimes you do lose your shit, but on the whole, it's like, right, if it's a constant thing, then we'd rather you just leave. So, he's threatened with criminal contempt. Oh, okay. Get me the cost then. I know we just in a stream. Just going to ask what the elders are doing. What's the elders? Who's the elders? Oh, yeah, they're going away for an event. That was unbelievable. KP showed up and told the court everyone that was trying to... She's a fucking moron. He's pissed, as he should be. What is the Commonwealth hiding? I just get bitchy. Erin's a good example. Erin's quite good now, actually. She gets pissed. Chicken dal soup. Oh, nice. You fed me daily, but I keep coming back for more. What's guess me is the victim once it's streamed. Oh, right. Does she? Okay. She's actually the definition of trash. Yeah. Well, it is what it is. I don't cover her. I don't want to give her any, you know. You get nicely pissed. No, well, maybe I said that wrong, but like I understand that somebody will lose their temper. You know, I do. What I'm saying is don't get offended, and that person, if they continuously lose their temper, they're gone. You know, they will be gone. You know, because we won't tolerate it. But like I tolerate somebody losing their temper once, but if they continuously lose it, then we'll, you know, sort it out. They'll be timed out. For their own good more than anything, because you know, no one's perfect. Everyone will lose their temper sometimes, but there's no really need to do it in a. I get nicely pissed. I don't know. I'm again tired now. I'm probably confusing the matter, but yeah, thank you, Wicked Psych. That's a good one. We do try and have discussions here, and a lot of it's down to you guys because you're the ones having the discussion. You guys are the ones that are being respectful to each other. So yeah, thank you to all of you. Right. I don't think we got. Are we got anything else to discuss? I don't think we do. What's the time now? It is now 10:15 nearly. So that was another, what's that, 5-hour stream today? Let me just check here just in case. No, that's fine. Aaron Hack. I'd rather be pissed off than pissed on. There you go. That's the attitude. That's the attitude. Aaron Hack, nicely pissed. Suggestion: if you want to cover Connor Gray again, have their own fun information, please do. Well, so was Mighty Meat as well. I like Mighty Meat's view on it as well. So I'm not sure if I will cover Connor Gray, to be fair. It was more of a no one else is covering it type of thing, you know. But I do understand it's important. Rhonda, there you go. So yes. Anyway, we'll see what happens with everything. And because there's no trial date for that anymore, so that might, I think that'll probably clash with some of the other trials anyway. That case, because well, you got Walsh, you got Courtney Clenny, so October, November, December, then obviously January, leading up to Lindsay Clancy in February. So 100%. 100%, and that's what I mean about timing out. You know, we've shut some people off and they've left the channel, but it's like, just because you have that opinion doesn't mean that everyone else has to have the same opinion. And I give everyone a chance. As I say, that's what I mean by everyone has a bad day, but if you consistently shutting people down, we just don't want you here. You know, simple as that. It doesn't matter how much you've been here. You know. I always use the Druid as an example because he's great and he doesn't mind being used as an example, but it's like having a conversation and being like, dude, I mean, people get offended, so it's like, we're going to time you out, but there's a limit, you know. So but yeah, I hope everybody is always respectful. Crumby's in depth and knows the lower part. It just said, I know, or an order, I know. Yeah, I don't know if I'm going to cover it, to be fair, but there are so many trials going on. As I say, we've just gone through them now. There's a ton. Disagree with me. No, but also it's hard as well. Also, the mods have got opinions as well, you know. So we've all got opinions. The mods have got it, and you know they have to sometimes, you know, deal with people that they agree with. They might agree with somebody, and it's like, yeah, but you know, you can't just shut people down. So fair play to the mods, they have to try and be impartial, even though they're passionate themselves, you know. Yes, exactly. Part one of for BK's in this, and I sat that street. Yeah, I felt for you there. I felt for you. You were very passionate about that. But all praise to the mods as well, because you know, they are, you know, yes, you'd be surprised though. You are Wicked 100%, and I would say a lot of people are good faith argument. You would, but you'd be surprised if some aren't. You know, so. But anyway, it doesn't matter. You know, it is what it is. It is what it is. Yes, she is pulling nails on. But yeah, thank you everybody. As always, love seeing you all. I'll say that trial on Monday. Hopefully starts probably Tuesday, Wednesday. I know it's not for everybody because it's murder and dismemberment, but I'll try and look into it. So, oh, there we go. And yes, I'll leave it on that one, I think. Yeah, that's it. Nothing else to say. Right, I'm dragging it on now. It's a good sport to have us troll in the chat now and again, though, isn't it? Oh, it is, yes. It is sometimes, yes. Thank you, Wicked. No, thank you, guys. You make it worth it. So thank you for always contributing. Because if you don't contribute, it's not worth it, you know. So thank you. No worries, lovely. I'm off as well. So have a wonderful weekend. No DUI yet. No drinking under the influence, please. Thank you very much, lovely. Yeah, you're out. Oh, shit. That means everybody has to be out if Aaron Hack is out. And you as well, Rhonda. Thank you, everybody. I'm going to end the stream right there. So thank you. Take care. And I'll see you all on Monday, 2 o'clock Eastern. 9 o'clock Eastern, 2 o'clock UK time. Take care, everybody. Love you all. Well,